Hello, good morning. My name is Mroczkowski and I work as Public Policy Director at IAB Europe. I'm very glad to be given this opportunity to speak to you today, especially as it follows an interesting conversation about Privacy Shield. And before I really start, I would actually like to say that we've been active on this matter too, liaising with our members. We have produced what is now a set of publicly available FAQs, and at the end of my presentation I would like to share a link to these. It's definitely a matter of interest for many of us. Now, when it comes to the scope of my intervention, I would like to speak about IAB Europe's policy and regulatory work, concentrating probably on two dossiers, which is ePrivacy regulation proposal and Digital Services Act package, the so-called DSA, as you might have heard of it. In other words, it will be an update on what is happening in Brussels. Before I start, a word or two about IAB Europe. For those of you who may not know us, we are a European-level trade association for digital advertising and marketing ecosystem. We have a dual membership, which means that we associate both national organizations such as IAB Sweden, as well as we have corporate membership. We see our mission as representing the industry on the policy and advocacy regulatory front, but then also to ensure that industry works together, collaborates to create relevant frameworks, codes of conduct, industry standards. All up, we associate over 500 businesses across Europe, not only in the EU, and it really comprises any player in the supply chain. So starting from the buy side advertisers or agencies, going through to the intermediary bucket with a host of technology companies, and finally on the supply side, the media, publishers, apps. When it comes to our objectives on the policy and regulatory front, we obviously try to demonstrate the value of data-driven advertising. We also try to illustrate how the industry is compliant with the existing law, especially when it comes to privacy and data protection regime. One risk that we keep on seeing is that the digital advertising, and especially as currently practiced, which means that it is data-driven in a variety of ways, could be prohibited or made commercially inoperable, and this could happen by in a variety of ways. It could be a bad outcome of ePrivacy regulation proposal. It could be also a very suboptimal scope of the Digital Services Act. It could also be a regulatory enforcement, and here we have invested a lot of our resources on the legal compliance side of things with the transparency and consent framework. So that's for the background. And now diving a bit more into ePrivacy, but still highlighting why it is relevant in the first place. Though I guess I don't really need to remind anyone of this. ePrivacy regulation proposal is discussed as a next iteration of ePrivacy directive, and this directive is considered to be part of ePrivacy. EU privacy and data protection framework that is relevant for digital advertising. So this will be unchanged in the next iteration. As you will probably know, EU institutionally, there are quite a few different actors that have a role when it comes to discussing EU proposals. So it usually starts with the Commission, European Commission, putting forward the very proposal for ePrivacy. That was in January 2017. Next one, we see activity on the Parliament's front. where the Parliament takes a stance on the file. In the case of ePrivacy, that happened later that year in October. We also have the Council, where the member states chime in, and here, well, this has been ongoing, at least for ePrivacy. We are 3 years after the release of the original proposal, and the Council hasn't agreed on its broad lines. As you will see, there have been quite a few different presidencies looking at the file. It started with Malta, 2017. We are now in H2 2020, where we have German presidency. So as you can see, it's quite a controversial dossier. And maybe before I go into an update into the details of what's been happening lately, I shall also make it clear what's relevant from our perspective. We are looking at a set of three issues that are most relevant or contentious from our perspective. So the first one will be the so-called tracking walls or cookies walls prohibition. That's Article 8, and we strongly believe that publishers should be able to make access to their own content conditional based on user consent. The next issue, or the next priority, is allowing exemptions to the consent rule. That would normally also happen in Article 8. We are talking, for instance, about exemptions when service providers want to avoid any fraud or want to measure their services in an appropriate manner. And finally, there's in the original proposal also Article 8, which talks about mandating browsers or operating systems a possibility to really govern obtaining of that user consent. We believe that law should be technology neutral, and we are not supporting this provision. When it comes to the latest developments, as I've mentioned, the file remains in the Council, so the discussions are being driven by respective presidencies. January, July, it was the Croatian presidency. As IAB Europe, we have worked with the local players to make necessary connections. I would actually say we had a good rapport with the presidency, and that comprised both regular contacts with the team over here in Brussels, as well as face-to-face interactions at the ministerial level in Zagreb. What is probably more important and more interesting is what happened on the substance. Well, there the presidency proposed introduction of legitimate interest legal basis. So that was a major game changer. But their proposal did not get enough support in the Council among the member states. I should also say that initially, the way the legitimate interest was proposed, it was suboptimal from advertising industry perspective, not immediately useful. The discussions were locked in a stalemate, and that's both due to the disagreement on the substance as well as COVID-19. And so we saw little activity on that front, on ePrivacy front, for the remainder of the presidency. I think actually the presidency, because of the initial reaction to their ideas, was actually quite happy to put the file aside. German presidency was inaugurated on 1st of July, and thus far the major development was really a discussion paper put forward by the presidency to revisit different approaches to, among other things, to Article 8, which is of interest to us. We have been liaising with attachés in Brussels, working with some of the national IABs to communicate our points in the EU capitals. So far, we haven't really seen a new compromise text. We are expecting it in the coming days. It's a well-known fact almost by now that the new compromise text, as far as the Article 8 is concerned, will build on the Finnish presidency proposal approach. So only consent, no legitimate interest in short. It's probably also important to say that that it's a political goal of the German presidency to agree on a general approach by December, by the end of their mandate, and to move the discussions forward to a negotiation stage with other EU institutions. Let's see what happens. We'll be more than happy to keep you posted. Now, going into a section about Digital Services Act, I think it's relevant, it's pertinent, it's critical to really ask a question: what is it that we're actually talking about? Because at the end of the day, DSA means very different things to different people. Many look at it through the prism of social media, big platforms. Also, the so-called gatekeeper platforms issue has surfaced a lot. DSA is also supposed to look at a revision or an update of the liability e-commerce directive liability regime. Advertising is somehow, in many different ways, part of this scope. So that's why we really need to be observant. Officially, from the Commission's perspective, as has been communicated, the Digital Services Act would be looking into revision of rules that will help to deepen the digital services market, single market, and there has been also talk about ex-ante rules for the biggest players, the large platforms. But again, we know for a fact that advertising in a variety of ways is definitely something that the Commission is paying attention to while reflecting on the Digital Services Act. What has happened so far is we actually don't really have a fixed proposal yet, but the DSA really is a subject of the subject of many discussions. The discussions actually at the policy level in Brussels, also industry level, started back in 2019. The DSA was formally mentioned in the Commission work program in January 2020, beginning of this year, where it was confirmed that this is going to happen. In April, we have seen some activity in the Parliament, where 3 different committees have been looking at the file. These are own initiative reports where Parliament is advising on what, from Parliament's perspective, an optimal scope of a file will be. So they are not commenting yet on a fixed proposal. In June, we saw the start of the public consultation. We have worked within IAB Europe on a submission, and I will say a word about this shortly. We are now expecting the proposal for the DSA package to be released in December. It could also happen beginning of 2021. And now I arrived at what IAB Europe has been doing, and I have divided it into 3 parts. So pre-consultation, during the consultation phase, and what we are doing right now in the post-consultation phase. As I have mentioned, we had known about the existence idea for the DSA dossier long before anything has really happened. So we have been engaging with the relevant Commission units and departments, making them aware of who we are. We have also put together with IAB Europe, within IAB Europe membership, preliminary comments on the DSA. That helped us in that advocacy, both vis-a-vis the Commission, as well as the Parliament. Obviously, there is also some interest quite some interest from the member states' perspective, and I'm pretty sure that's also the case for Sweden. Now, during the consultation phase, we have honed our views initially communicated in these preliminary remarks. These are actually now publicly available, so I invite you to have a look. Should that be of interest to you, we made our submission in September, and I think it's also interesting for those of you who want to understand the bigger picture better, the European Democracy Action Plan, as there is some overlap with the DSA. As I have mentioned, DSA means different things to different people. From our perspective, we've been trying to highlight already the good work that has been done, especially in the domain of transparency and accountability, showcasing the industry-driven approaches when it comes to buying and selling ads in the digital ads ecosystem. That's one of our messages. We've also advised that in many ways the current liability regime is an optimal one. And last but not least, we have communicated that DSA should not become a second GDPR. So as I said, we are expecting more to come towards the end of the year. We are expecting the DSA package to be actually released by the end of the year. Until that time, we will obviously continue communicating our views across the different EU institutions. We will hopefully work with also with national IABs to ensure right level of advocacy in the EU capitals. I think the big question is, what are the stakes for the industry? So we clearly know that that the Commission has advertising in scope in one way or another. The issues that have been called out are transparency, trust, accountability, speak to these aspects where we can already demonstrate good work of the industry. So I think it will be pertinent to continue communicating about this. But it's also true that from some of the Parliament's reports, we see that the Parliament continues really to scrutinize the business model of digital advertising and targeted advertising in particular. So we should not forget about this, and I think the Parliament will want to play an active role in the DSA process. Now, there is little time for anything else, but I just wanted to flag a few other things that may be of interest to you. AI is really high on the agenda. It's been for a while now. When it comes to automated solutions that are powered by data, of course, GDPR is relevant, but there is also a push to be a trendsetter when it comes to AI legislation, AI policy. That's the interest of policymakers in Brussels. So I would say watch that space. When it comes to the digital tax, at this point in time, negotiations are happening at the OECD level. So that's really the global level, but we've also seen some developments in respective EU member states. Off the top of my head, that would be, for instance, Austria. I think the UK too. Although obviously now it's a different situation post Brexit. I shall also say that disinformation and broader EU media agenda is an important topic, and IAB Europe is a signatory to the EU level code of practice on disinformation, and we are active in that regard. So with that, I shall finalize my intervention. I hope it's been interesting and useful. I welcome any questions, but also invite you to any bilateral exchanges should you be interested in discussing things further. Thank you very much for your attention.